Well, I thought Professor Brofalt's comments were not academic. They were wildly practical. The four folks we're going to hear from now, though, will bring to the discussion experience almost like none other can in a gathering such as this. Let me just briefly sort of highlight the careers of people, decades long of extraordinary distinction. We're going to go from left to right, and as I said before, each person will speak from anywhere between 7 to 10 minutes. But the first two speakers are amongst the most distinguished representatives in the modern history of the New York State Senate and the Assembly. John Dunne is an icon. He's one of those people, if a young lawyer came to you or a young person came to you and said, what do you want to be when you grow up? Tell him to be like John Dunne. He is a pillar of the New York bar, almost like none other. Not just an extraordinarily distinguished 23-year member of the New York State Senate, not just the head of the Department of Justice Civil Rights Unit during some of the most tumultuous periods in American history, the Rodney King episode and all of that. He was the point person for the United States government on those issues. But something Senator Dunne doesn't talk about, but makes him certainly one of my heroes. In the darkest days in New York history, during the Attica uprising, when our governor at the time, unfortunately, didn't go to the prison, a young senator from Long Island, no less, thought it necessary to personally make the trek to Attica. That was one of the most tragic events in New York history. But for those of you who ever have the time, you ought to read the report that was produced by the commission to investigate the Attica uprising, because the one person who they identified as a bona fide hero who went to the prison, who met with the inmates, is Senator John Dunne. An extraordinarily brave and courageous and distinguished man, as is our next speaker, Richard Brodsky, a 16-term assemblyman, a battler for social justice like none other during his time in the New York State Assembly. Former chair of the Environmental Conservation Committee, the author of innumerable pieces of legislation, including one of the more significant public ethics government reform pieces of legislation we've seen in recent years, the Public Authority Accountability Act of 2005. Our first two speakers bring to the discussion sort of the experience of the legislature. We couldn't ask for two better speakers. Nor could we ask for our next two speakers. So when we talk about ethics enforcement in New York, we are talking to people who don't just talk the talk, they have walked the walk. These are two former executive directors of the New York State Ethics Commission. It has had different iterations since then, but I would say, whatever the critics might have said at the time, their tenure in that commission, on the whole and by and large, I think their tenure was excellent. And relative to where we are today, interestingly enough, I think the commission did very fine work in certain areas. But a word or two about Karl Sleight, a highly distinguished public service career. He's now a highly distinguished private practitioner. But let me see, a former chief assistant district attorney, a former assistant attorney general who focused on public corruption prosecution. Yes, an executive director, also a former inspector general of the state of New York. Truly a distinguished public servant and now a distinguished private practitioner. And Richard Rifkin, well, for this audience, you don't need really much of an introduction. Amongst the most distinguished public servants, not elected public servants in modern New York history. Richard has seen everything, and he's done everything. In addition to being a former executive director of the Ethics Commission, for years he served in the Attorney General's office with tremendous distinction. He was a first assistant attorney general under Robert Abrams. He served after the Abrams term during Eliot Spitzer's time as attorney general, as the head of the Division of State Counsel. Richard has done everything, seen everything, as have all of these folks. So let me just ask, starting with Senator Dunne, if you'd favor us with some observations, and then go from left to right, and then I'll have a few questions.
Thank you, Hank. It's great to partner with you once again. I'm working with Hank. He's chairing the New York State Bar Association Committee on whether there should be a Constitutional Convention in 2017. It's good to be back with you. And let me just use the few precious moments that you've entrusted to me to give you really a broader view with regard to this whole issue that has brought us together today, and for us to focus on whether ethics should be addressed in a constitution and at a constitutional convention. I think it's worthy to consider the lesson of a few years ago with regard to the preparation for a 2017 our proposed convention, and not lose time by failing to recognize prior attempts. Let me take you back to, if any of you can remember, 1966, quickly, that's about 50 or 60 years ago, when it was proposed to study whether or not a recommendation should be made by the electorate to hold a constitutional convention. And it's curious that actually it was 56. It's interesting that then Governor Harriman felt there ought to be such a commission in advance of that. And guess who he elected or chose to be the chairman of that commission? Nelson Rockefeller. 2 years later, Nelson Rockefeller, having learned what he did in part of his study and recommendations, ran against poor Averell Harriman, and guess who won? So that's a lesson to anyone thinking about being in politics. Be careful of who you pick. But anyway, but it was very interesting that the governor pointed out three institutions, really, which are part of our meeting here today. The Rockefeller Institute of Government, the Albany Law School Governmental Law Section, and also the New York Bar Association. And in preparing for his report and speaking to the public, he mentioned, among other things, that there ought to be, and he did form, an inter-law school commission on constitutional simplification. And when he spoke later to the Rockefeller spoke to the New York State Bar Association, he observed quite appropriately that no group of the state which is more interested in this question or whose judgment and informed opinion can be more helpful to the voters in deciding these issues than the New York State Bar Association. And so with the Rockefeller Institution, with the Bar Association, and with the Albany Law School, we had what former Governor Malcolm Wilson would have referred to as a fortuitous coincidence of felicitous circumstances. And some of you may remember those pearls that he was able to articulate so well. I had trouble rehearsing this for a good while. But so learning from the lessons of the past, you might say to yourself, well, we have enough. Well, really, why are we here today? We are here because we are concerned about one word: corruption. Corruption, a subject which just happened to be the subject of 5 separate articles in today's edition of the New York Times, is a term that we have wrestled with over the millennia. And so I turned to one of my tutors, our good friend Aristotle, and when he was talking about corruption, he said, and I quote to you, because I want to be careful of this, because it's really the bedrock of what we're talking about today. When the good of one man, in those days, women didn't have a voice, when the good of one man takes precedence over the common good, which must be the goal of a rightly established and strictly just government, it is corruption. And that, unfortunately, is what we have seen almost on a daily basis, not just in our backyard of New York State, but across the country, where we have people who are involved in government now, and Karl and I were lamenting the fact the scene has somewhat changed, who are more interested in survival than service, or who seek complete victory over compromise. And Aristotle cautioned further that where corruption is ignored, it leads to tyranny. And so I think we should address quite earnestly the question of what role we should have as informed citizens in helping our fellow citizens to understand the issues which could be presented at a constitutional convention, so that their vote in the 1917 referendum would be an informed one, and one which would be in the best interest of the common good, and no longer viewed by someone as interested in simply their own narrow interests. And so we are here today to consider really what should be included in our sacred state constitution. I looked at the first article on civil rights. Jury trial, right to worship, the right to habeas corpus, the right to enjoy the protections of civil rights, the right of labor to organize, and the right and security of private property. I think we have to ask ourselves, should we not include among those basic civil rights the right to expect that public officials will fulfill their fiduciary role to which they have pledged, and in return we have pledged our confidence, something that may be slipping away a little today. If we were to have that include some semblance of a declaration of civil right to fair and decent government performed by people who are committed to service and not just their own advancement, we ought to look first at our state code of ethics. The professor referred to Section 74 of the Public Officers Law. While it is a series of thou shalt nots, they embody within those 6 or 7 sections within Section 74 basic principles identifying and defining the responsibility of an elected official to the public. I believe that we should give serious consideration to whether a Bill of Rights for our state constitution should include those rights which are set forth in statute, but which, once again, the professor pointed out, could be changed on the whim of the legislature. I think the people deserve more than that. In addition to that, we have to consider questions of education. Should standards be in the Constitution? Voting rights, same-day registration, something that, once again, the Bar Association is wrestling with. The Environmental Bill of Rights, should this provision with regard to forever wild and clean water be reviewed? In the courts, should there be a civil Gideon enshrined in our state constitution, much as the United States Supreme Court has said that everyone charged in a criminal case is entitled to and should be assisted in achieving the realization of being representative? And should local governments be protected against unfunded mandates and occasional financial control boards? These are critical issues. We've got to look at them without fear, but on the other hand, look at them being educated. And I take my hat off particularly to my very proud professional association. That's precisely what we're trying to achieve through the committee that Hank is now chairing. Study the subject, point out possibilities, and yes, make recommendations, not just on whether, up or down, we should have a convention, but that we should identify specific subjects which are key. I thank you for the opportunity to visit with you, and I look forward to the really interesting part of the program when we hear from you.
Well, good afternoon, and thank you for this opportunity to join with some far better qualified and more distinguished people. I go back with John Dunn to when I started, and he was fairly experienced. I was 6'2" when I met him, and I have benefited from the relationship ever since. I think I can be of most service in this discussion by trying to answer directly and narrowly the question, and then try to enforce some intellectual rigor on the vocabulary of the discussion, which, without criticism of anybody else, strikes me as something that has been lacking and we need. The direct answer to the question is there are some things in the field of ethics that are appropriate for constitutional inclusion. I believe that either by amending the Board of Elections provision or setting up a campaign finance board, the campaign finance reform is ripe for inclusion in the Constitution. Part of that reason, by the way, which will apply to all of these things, is not just that they're important enough, whatever that means, but that the process by which those issues can be addressed may be much easier than the conventional political process. You are more likely to get really good campaign finance reform out of a convention amendment referendum process than you are the straight political process. Two, the Constitution sets forth an oath of office, which guides members of public officials. That oath needs to be looked at. And it needs to be looked at in the way in which John Dunne presented the question, which is there some form of fiduciary obligation which can be included in the oath or in some other section of the Constitution, which I'm going to return to in a minute. There are some ethics issues which are not constitutional in nature. Doesn't mean they're not important. But the elements of a constitutional, of a code of ethics are better left to the normal political process. So having now directly answered the question put to me, let me talk about what I want to talk about. The title of this convocation is dealing with ethics. And it strikes me that we have never, as a Yale law graduate once said about a similar question, we don't know what the meaning of is. There is a real, everybody puts into the phrase ethics what they care about. It is clear to me that criminality, which is what has forced the public discussion of this, is an ethical issue. But so are non-criminal behaviors like campaign contributions. And if we return to the definition of corruption that John gave us, then there may not be that distinction between criminal activity and non-criminal unethical activity. It's all the same thing. If it is all the same thing, it is ripe for constitutional consideration. That is to say, it is perfectly appropriate for the Constitution of the state to set forth its affirmative expectations of how people in public life will behave. Unfortunately, in the conflation of legal, unethical, and criminal, there's been a narrowness of intellectual inquiry, so that what we're really left with when it comes to do something about ethics, governor and legislature, well, pension forfeiture, more disclosure of non-conflicting behaviors, because conflicting ones are already disclosable, and maybe no more outside income. Whatever else are the merits of those proposals, they will not cure what ails the body politic. And it seems to me, to go back to what John said, and to try to wrap this in a positive way, punishment, disclosure, sneering, and exasperation are not solutions to the ethical problems of the state of New York. We ought to present to the people and to public officials, and by the way, let me just pause here. My esteemed colleagues keep referring to the legislature. As best as I understand it, about 10% of the legislature has been dragged out in chains in the last 15 years. About a third of the governors have been dragged out in chains. This focus on the legislature is a political and inadequate prism on which to discuss this issue.
All right, got that out.
Oh man, and I can't. Unfortunately, I'm not going last, so we won't hear the end of that. To again wrap this up in an affirmative proposal, by offering a legal, constitutional, inspirational, and aspirational vision of what public ethics are, you are infinitely more likely to get a positive overall result. The great truth of the matter is, as many times as you haul a member of the legislature out in chains for stealing, there are plenty of laws against stealing. The big, if by the elevation of the interest of one over the elevation of the many is the definition, campaign finance is where the corruption occurs. It beggars the rest of it. And instead of focusing on things like pension forfeiture, it's a worthy discussion, or disclosure of non-conflicting clients, or my favorite, borrowing earned outside income. You can get as many dividends as you want from General Motors, you just can't work for them. I propose that we take the Dunne position that we find a way within the constitutional structures we have to force a constitutional resolution of the question is, what is the fiduciary obligation of public officials to the people of the state, their districts, and the state government itself? You do that, and you deal with campaign finance, you'll change the way the state works. Thank you.
I come at this from, I think, life experience, and a lot of this is based upon the time when I was a young assistant district attorney. And when you went to court as a young assistant attorney, it was drilled into you that the purpose of you being there was to represent the people of the state of New York, not just to get a conviction. And very often, and almost sometimes on a daily basis, you were there to try to make sure that justice was done, and that could include making sure that a defendant who was indigent was not taken advantage of because maybe his lawyer hadn't gotten enough sleep the night before, or the judge was in a bad mood. So those kinds of things start to frame my approach here, and I think have carried with me to some extent when I was at the Ethics Commission, the IG's office, and I was also involved in a private side in representation of entities and people in the Moreland Commission investigations most recently, which we'll talk about a little bit. But the question is, what's the problem? And if you have a problem, and I think we do, the question is, how do you fix it? And what do you do about it? My son comes to me periodically, he's 16 years old, plays a lot of baseball, says, "Dad, I want to play center field this year." I'm like, "Great, what are you going to do about it?" And he sits there and he thinks, he goes, "Oh, don't say it, don't say it." I said, "Yep, a goal without a plan is just a wish. You don't wish you want to play center field, but you want to play center field. What's your plan? How are you going to get there?" And I think that's something that we have to talk about in the terms of ethics in the Constitution. If you're going to try to improve government in New York State, what are you going to do about it? What is the plan? Is it the Constitution or is it something else? And I think to Richard's point, one of the most difficult issues is defining what is ethics, because if I asked every single person in this room, and if I asked my fellow panelists, we would all define it in a very, very different way. And I've written on this subject over the last 10 or 15 years, and I found one, I think, very good discussion of what ethics is as it relates to government. I'll read it for you from a very august body from a little while ago. The essence of ethics. This problem of ethical standards is not the simple issue of bribery and corruption on which there is no difference of opinion. It involves a whole range of borderline behavior, questions, or propriety, and the questions of conflicts of interest. Involved is not only the raw material of partisan politics, but the lives and reputations of honorable men and women who have made a career of public service. Also involved are changing standards. Integrity in government has never been and probably never will be subject to an absolute standard. Conduct in public office, which was once condoned, would now be universally condemned. A century ago, it was taken for granted that legislators represented special interests, public officers who used inside information to feather their own nest were not condemned, but envied. The issue of public office for private gain was the order of the day. Today, we have progressed far beyond these 19th century standards of political morality. The best evidence of this progress is that we expect not only the fact of personal honesty, but the absence of any reasonable suspicion of dishonesty or even impropriety. It'd be great to live in a state or a place where that was true. Those words were spoken in 1954 from the Special Legislative Committee on Integrity and Ethical Standards in Government in the New York State Legislature. So if past is prologue, I think that's something to think about. I think it very well frames the issue. But the point is, this has been a difficult issue for our government for over 60 years. And it's manifesting itself today in a lot of different ways because people don't know how to behave. You know, is something criminal? Yes or no? You know, people I think who are in public service sometimes don't know the answer to that because the interpretation changed despite the fact that their behavior may be static for decades on end if you're somebody who served in public service for a very long time. You know, and then the question is, what do we do about it? I can tell you what we don't want to do about it. It's what we've been doing for, you know, since I've been involved in this issue. This issue was alive when I was an intern for Mario Cuomo in 1986. The Ethics in Government Act of 1987 passed. We had the scandal in New York City. We had the Ornstein issue in the Senate. But it's something that's perpetual. So when we have government scandal, we have a government scandal and there's an immediate public reaction. We got to do something about it. What are we going to do? And what does the legislature do? Pass a law. That'll fix it. That will not fix it. That will not fix it. If you add more categories to the financial disclosure statements, which are horrendous, that is not going to make government more ethical in New York State. If you tweak and work around the edges on some laws that are not real great as they read now, you're not going to fix things. But the problem is the response. And, you know, what invariably happens is, you know, there's a scandal, there's a public reaction, there is sweeping reform. If I hear sweeping reform, you know, again, I think I'm going to be sick. And what you ultimately get is these completely ineffective laws that don't address the problem or address some narrow problem, and then there's a press release and a press conference. Everybody says what a great job they did, and then the issue's gone. And that is the frank reality, and that's why I'm very rarely on these panels because I say things like that and I get in trouble. But when I think about that, I think about the wise axiom and wise words of Thurgood Marshall, who said, "The Constitution does not prohibit legislatures from enacting stupid laws." You know, it is absolutely true, particularly in the area of ethics laws. So the question is, can you do something about ethics and the Constitution and in that vein? I think the answer is yes, but I get there in a different way and I look at it through a different prism, you know, having been on the inside and the outside in a pretty active way. I do not think that it is a good idea to try to raise to the level of constitutional status an ethics commission. Imagine if we had made the Commission on Public Integrity part of our state constitution. Those guys unraveled faster than a bad fly fishing reel. They were horrible. And thank God they're gone, and thank God we had the ability to at least change them. Now, I'm not saying what we have now is better, but we know that the CPI was horrible. If you want to do something in the vein of Constitution, I think, you know, what would be very valuable is increasing the tenure of legislators. So these members of the Assembly and the Senate, I'd be very interested in Richard and John's view on this. They're too short. They're perpetually fundraising. I think if you took something more like the federal model, where you had a Senate and the Assembly, for that matter, having 6-year terms, maybe term limits of 3 terms. If you can't get things done in 18 years, maybe you try to find a new job, okay? So, you know, and then you could stagger the terms like the U.S. Senate, you know, whether it's a random number selector or somehow, but, you know, a third of your body is up for re-election every year. I mean, the amount of money that goes into some of these things is horrifying. We have a special election on Long Island. It's going to happen in April. Projections are that there'll be more than $2 million spent on each side for a Senate seat. That's insanity. Unless you're the newspaper or the radio or the television, it's going to take in a lot of that money, and then you complained about campaign finance. I think another thing that's certainly worthy of discussion for inclusion in the Constitution is the statute that is now in Civil Rights Law Section 73. And that is a McCarthy-era law that is invariably untouched. But what it does, it protected individuals who were the subjects of temporary commissions, government probes, things that included the Moreland Commission example, and that statute was in play during the Moreland Commission investigations. If a mid-level government official in New York is subject to a state ethics inquiry, they have to pay out of their own pocket. There's no opportunity for indemnification if they are completely vindicated at the end, and you have a very, very dangerous dynamic now where people just throw up their hands and say, I didn't do anything wrong, but I'll admit to it anyway, and that's horrifying. And I represented someone who's the president of the SUNY Research Foundation for 7 years. He lost his job because of political pressure. He litigated the case, he fought the case. After 7 years, the ethics charges were dropped. The Attorney General dropped their case, and a condition of us agreeing to it was that my client had agreed not to sue the state of New York. That's a horrible, horrible case, and that only happens when you have weak and infirm and poor judgment in your ethics commissions. My personal view on a lot of these things is we do not think big enough. We tinker at the edges. We talk about pension forfeiture. We talk about a full or a part-time legislature and things along those lines. But really, in reality, we have a crisis of inspiration and we have a crisis of participation. And we don't have good people who are running for the library board, your village board, things along those lines. And those are a real, real problem in a democracy. I don't know what to make of the presidential politics, and I'm not going to weigh in there, but there's two things that I think are fascinating that have nothing to do with ideology. Bernie Sanders is raising more money than Hillary Clinton from a lot of small donors. That says something to me, that there's something out there. Donald Trump is bringing more people to the polls, I think, than have ever come out before. And if you look at certain breakouts in polls, a lot of new people. There is a lot of frustration out there in the electorate, whether it's at the federal presidential level, at the state level. And I think if you're an elected official in New York, you have to be very sensitive of what's going on. Thank you.
Well, thank you for coming to this. This is a great pleasure for me. I really had a fabulous opportunity to work with Hank and Senator Dunn in a committee of the Bar Association, our Constitutional Convention committee. And every time I come out of one of the meetings of our committee, I get the feeling that this is one of the most interesting meetings I've ever attended. They're fabulous. They're fabulous. And I wish more of you could hear them. The discussions are intense, very sophisticated, very technical, and very wise. And it's a terrific committee, and I enjoy it enormously. So I tend to agree with what some of the other speakers have said here, especially Assemblyman Brodsky. We have to, before we move ahead with anything, we've got to identify the problems that are in front of us. It's, as Karl said, it's easy to have a laundry list of items and say this is what should be done. But a serious effort has to be made to identify where are the problems and how do they need to be fixed. And that's what I like to talk about. And then, of course, the question is, should they be in the Constitution? And I must say, with regard to the Constitution, I guess I'm the skeptic on this panel. Because frankly, I'm not sure a lot can be done within the Constitution. But to identify the problems that we have in this state, when we talk about ethics, many people think about the behavior of our public officials. How are they behaving, if you will? Are they
Are they meeting their obligation to serve the public? And the question is, do the laws we have now guide them in helping them serve the public rather than their own interests? And my feeling is that the laws do that at this point. I don't think there's a significant problem with the laws that govern the behavior of our public officials. We have a problem to the extent that public officials are not obeying the laws, but if the fact that we've had this problem means that there are laws that they're disobeying. After all, if the laws weren't there, they couldn't be convicted and they couldn't be found in violation of the laws. So on the whole, you can always say that there can be improvements. You never say the laws can't be improved. But on the whole, I think the laws guiding the conduct of our public officials are really pretty good. You can argue you'd like a little bit more disclosure of some of their interests. Maybe that will help, but that's at the edges. And none of that is in the Constitution. I guess the one item that people have talked about, which might go into the Constitution, would be making the legislature a full-time body and limiting outside income of legislators, because that's structural. And therefore, if we want to talk about that, we can talk about that as a constitutional issue, although it's my feeling, again, that that's really at the edges. That doesn't go to the core of what we're talking about here. I guess the question then is, why do people disobey the laws? Why do we have people going to jail? They're not deterred. You've got to find not new laws, but maybe a better deterrent to disobedience of the laws. And my own instinct is that maybe pension forfeiture would do it. Maybe people would think twice about violating the laws if they thought about the possibility, not of going to jail necessarily, but of losing their pension and how it will affect them for the remainder of their lives, and even more importantly, to some degree, how it will affect their families. Now, if you're going to do pension forfeiture, then you have a constitutional issue. As Richard Briffault was pointing out, the legislature has been talking about a constitutional amendment. They have not yet, they have not obviously yet dealt with it. So where's the problem? And I submit, and I'm not the only one on this panel clearly who feels that way, the problem is in campaign finance. It's open season. There are basically no laws that truly restrict campaign finance. I know we have some. The campaign finance levels are exceedingly high. Look at what we have here. I work for the New York State Bar Association. We are a registered lobbying organization. We can't buy a tuna fish sandwich for a public officer or employee under the state's lobbying and ethics laws. And yet we can give thousands upon thousands of dollars in campaign contributions. Does this make sense? We don't, in fact. The Bar Association has decided not to have a PAC, and we don't make those kinds of contributions, but we could. And so we need to address campaign finance. Should it get done in the Constitution? I doubt it. Campaign finance, campaigns are changing. We're moving into social, campaigns are dominated now by social media. It's all a constantly changing and evolving process, and I don't think you can lock campaign finance into the Constitution. Do things change? Just look at the Kennedy-Nixon debate in 1960 and compare it with the presidential debates we're having today. So, could there be something in the Constitution? Possibly. And I would say the one thing we might put into the Constitution is require the legislature, mandate the legislature to develop a system of public financing. That could go into the Constitution, and it'd be a direction to the legislature. But that doesn't totally solve the problem. Public financing is not a silver bullet. Number one, it can easily be defeated by not giving enough money to the candidates. Look at our presidential system. There is public financing for the presidential campaigns, and no recent candidate has ever accepted public money because the system doesn't work. You need a workable system, and that has to be developed by the legislature. And there are issues. What do you do about very well-to-do candidates? The big example, obviously, being Michael Bloomberg in New York. How do we have a public finance system that allows a candidate to be able to effectively campaign against somebody who has that kind of wealth? Or take now, after Citizens United, independent, non-coordinated expenditures. A candidate can have an organization spending fortunes of money, unlimited amounts of money in support of the candidate, and if you have public financing which restricts his or her adversary, you've still got the imbalance. So public financing may well be an improvement, and it may well stop some of the problems, but it certainly is not a silver bullet. And certainly if you're going to do public financing, I think you could do no more than mandate the legislature to do it in the Constitution. Now, I'm certainly open to ideas from others, but frankly, from my perspective, I just don't see the Constitution as the mechanism for effective ethics reform.
I have a few questions, and I'm going to try to be a bit of a devil's advocate and maybe a provocateur in order to sharpen some issues. So what I'm about to say doesn't necessarily reflect what I might think, but Senator, let me start with you. And if I heard you right, you made suggestions that would sort of put you solidly in the camp of there are things we could do in the state constitution that would address ethics issues. And I think everyone here, everyone in this room will stipulate there is a problem, a tremendous problem. The public's got it right that needs to be addressed. So here's my question, though. The New York State Constitution is nearly 6 times longer than the federal Constitution. If anything, it's too long. It's too prolix. It's too unreadable. The federal Constitution, hailed around the world as a model of what a fundamental charter should be, I don't think there's a word of it that we could fairly characterize as an ethics reform. There's Bill of Rights, there's the structure of government. Why is the state constitution the appropriate place to talk about fiduciary duties and all of that? Why not a statute or a regulation?
I think because we are in perilous times right now, requiring very special response. I believe that the confidence, as the professor has pointed out, and the public in the performance of our public servants has gotten to such a low level as to warrant responding with very strong measures. We came here to discuss an issue, first, whether there ought to be a convention, and second, what should be the subjects. Like some of my colleagues here, I'm not convinced either that we should have one or what the agenda should be. But I believe that we are in such a perilous situation with regard to public confidence that it should be enshrined in the Constitution of our state to put everyone on notice that this is a priority, almost number one concern for the public. And after all, the Constitution is an expression of the public mood, the policy of how our community should treat one another with the protections of the government. So that's a long-winded answer, but I think that it is so crucial today that we stand up. Let me just conclude. When you had legislative leaders being convicted of major federal crimes, there's got to be a trickle-down theory. Leadership comes from the top. And when there is a sense of compromise verging on corruption, I think that there has to be a real wake-up call, not only for the current incumbents, but for any of us, and I'm thinking back 60 years ago when I started in government, on notice that that is your primary responsibility, being faithful, not just taking an oath of office, but faithful to the general public, not just your constituents.
Assemblyman Brodsky, you made the point, and let me just say, throughout your tenure in the Assembly, you were the embodiment of someone that was perceived, and rightly so, as a champion for the public interest. The remarks you just made, though...
Not everybody.
I think most. And yet, though, you felt the need, I think Karl slapped you on the back, to come to the defense of the legislature. Let me ask you this. You make the point, I think properly so. There's every bit of, as great a crisis with executive branch officials, governors in other states being hauled off in handcuffs, as well as legislators. True. But for those like Senator Dunne, who argue that the Constitution is the appropriate place to bake into it provisions that would enhance public confidence in government, I think that argument, although he didn't make it, I'm going to make it, in large measure can be focused on a legislature that could pass laws that does campaign finance.
A legislature and a governor.
Okay, but allow me to finish my point. By the way, you, critic of Silver versus Pataki, believe that there is a lawmaking branch of government and then an executive that executes the laws. I get it. The governor gets to approve or disapprove. But I want to talk about the lawmaking branch of government. In at least the modern history of the state legislature, you'll correct me if I'm wrong, I don't think the two branches have come together and ever put on the table of a governor something that would be described as a model of how redistricting ought to be done, or a model of how campaign finance can be done. And so, given how strongly you feel about this, how would you answer those who say, we need the Constitution and a convention to sort of do these things because the legislature won't do it? It's a rhetorical.
I would agree in many cases. Trying to correct the vocabulary of this discussion is not a defense of the performance of either or both houses of the legislature on substantive issues. Lots of times we'll continue to get it wrong and to do it for the wrong reasons. Okay? But that's not the question before the House. The question before the House is, what's the problem? What do you do about it? John is right that it ought to be in the Constitution, but for the wrong reasons. Let me suggest to you that the notion that there's this huge public outcry outside of this room, 12 Google groups and the editorial boards, go ask the voters when they're voting about what it is they're looking for in a candidate. You won't see this very high up. And you'll note that in many cases, semi-convicted felons get reelected. Now, the people are either morons, which I don't think is the case, or the issues before the people are much more likely to be education, taxes, jobs, the economy, the environment. Now, if that's correct, and I think it is, then this hue and cry, you know one of the reasons it isn't going anywhere? Nobody cares. Now, that doesn't mean we shouldn't do something about it, and that doesn't mean that there aren't really bad things going on. It means that we need to rethink the nature of the debate. If you're a tenant, worry about the LLC law. If you're a charter school guy, worry about the teachers union. But not because they're handing envelopes full of 50s to people in the middle of the Capitol, because they're writing perfectly legal checks. Now, if we're going to deal with this, and I'll just finish with this, stop talking about the legislature as the nexus of the problem. It isn't. It's by and large honest. Most issues are handled on the merits. Those that are not handled on the merits because of campaign contributions. And people try their very, very best to do it. The notion that you can leave the executive branch, the governor, the controller's office, 50% of them, 30% of the governors, 10% of the legislatures, 50% of the controllers got hauled out in chains. This discussion is going to go nowhere unless we get the public concerned about the connection between ethics and the things that matter to them in their lives. And that connection hasn't been made. Sorry.
Karl, I happen to agree with you. I think you put it very aptly that there is a crisis of participation and a crisis of inspiration. And some people take the view, I think you do, that one of the great crises that we're dealing with is that young graduates of Harvard Law School like Richard Brodsky or Yale College like John Dunn are not saying, gee whiz, as young lawyers, I want to go out and run for the New York State Assembly or the State Senate. That you don't see people sort of with those credentials and those backgrounds putting themselves in the arena and running for elected office. But at the same time, I heard you say, and I agree with you, that your point I think is an excellent one. At the same time, you basically said you didn't use the word nauseous, but something close to that. When
Nauseous probably worked.
Okay. When you hear about ethics reforms.
Yeah.
I don't want to miss it. It seems what I hear, though, is a counsel of despair. Mm-hmm. Don't do anything with respect to ethics reform. Mm-hmm. And we have a crisis of inspiration. So I'm being provocative, but are you saying we need our elected officials just to give better speeches and that will solve the problem? What's your solution to this crisis of inspiration and participation?
Well, on the inspiration and participation piece, I would bet that if I went along and asked everybody, there's some political figure that you could point to. It may not even have the same ideological background as you, that you could point to and say, that's why I got involved in government. It could have been Ronald Reagan, it could have been Mario Cuomo, it could have been John Kennedy, someone. You'd be hard-pressed, I think, in this generation for them to find somebody and point to, with millennials, someone that they look to get involved in government. I get the sense that there's just not that desire to participate, and it's a product of not being inspired. Now, what works hand in hand with that, not only do you not have an inspirational feature out there, but you have the opposite. You have legislators being convicted in federal court. So the notion of I want to be an intern and I want to work in the state senate or the state legislature, may not have that kind of idealistic appeal, which I think is very important, because I think that that core issue that you take with you on your employment journey or your professional journey is something that's very, very important. You look back at that and why did I get involved in government? Why did I go to law school? Those things are very, very important. And I think when you don't have, your parents being on the school board or, those kinds of things because they work two jobs and we're in a high-tech state and we don't have time to do it, I think you start to lose bits and pieces of what, is very, very important in a republic. So I think that's where they kind of come together in my mind.
So, Richard, I thought Senator Dunn made a pretty powerful point. Wasn't answering your remarks, but he made a pretty powerful point that whereas perhaps in the normal course you wouldn't think about doing ethics reform in the Constitution, we are living in a time where our options are narrowing. The legislature is not producing campaign finance reform, redistricting, pension reform. Doesn't the senator have a point? The Constitution or a Constitutional Convention might be the only way to get at those fundamental questions?
Oh, he's certainly got a point about the perception of the public and the problems that we face in terms of how the public looks at government. I'm totally in accord with him. The question, I guess, is how do you solve this problem? And putting into the Constitution might be one way to solve it, but I'm not sure in the end it's going to work. Can I take a second and give you a personal story, and maybe this helps is why my concern. When I was in the Attorney General's office, there's an airport in Piseco, New York, which happens to be in the Adirondack Preserve. And what was happening at the airport is, as trees do, they grow. And around the airport, what happened was planes were having difficulty taking off and landing because they had to get over the trees and it was only going to get worse. So they asked the Attorney General for opinion. Can we trim the trees around the Pasico Airport so that planes can take off and land? And we came out with, I'm convinced today was the right answer, no. And therefore, we had a constitutional referendum on the ballot so that everybody in New York, from Buffalo to Montauk, voted on the question of whether you trim the trees around the Pasico Airport. And the constitutional amendment passed. But that's what happens when you start to put too much detail into the Constitution.
Thank you. Well, everybody, thank Mr.